Sign over the savings account, Dorothy. All of it. Or I promise you, you will never hold those grandchildren again. Not a birthday, not a Christmas, nothing. That is what my son-in-law Craig said to me. He was standing at my own kitchen table, his finger pointed at my face, his voice so loud that the glasses in the china cabinet behind me rattled. 6 people were seated around that table. My daughter Lisa was one of them. She sat with her eyes fixed on her lap, her hands folded tight, her mouth sealed shut like someone had sewn it closed. Nobody spoke. Nobody defended me. The only sound in that room was the ticking of the mantel clock Harold built with his own hands 30 years ago. And somewhere, in the next room, my youngest grandchild, Jackson, was humming a song from a cartoon, completely unaware that his grandfather's kitchen had turned into a courtroom. I looked at the pen Craig had placed in front of me. I looked at the stack of documents he had printed out. I looked at the faces of everyone in that room, and then I reached for the pen. My hand was steady. It was not shaking from weakness. It was steady from certainty. So I nodded. I picked up the pen, and I activated something Craig never knew existed. Good day, dear listeners. It's Clara again. I'm so glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. Now let me take you back to the beginning, to who I really am, and what Craig never bothered to learn. My name is Dorothy Mae Ashford. I am 75 years old, and I live in Knoxville, Tennessee, in a house on Maple Hill Road that has been my home for nearly 40 years. I retired at 68 after spending 41 years as a bookkeeper for a regional credit union. 41 years. I started when I was 27, back when the statements were still handwritten in ledger books and every decimal point mattered because there was no software to catch your mistake. By the time I retired, I was managing a loan portfolio worth $14 million. I balanced accounts, I tracked interest, I spotted fraud before auditors did, and I never once made an error that cost the credit union a single cent. I say this not to brag. I say this because Craig Pemberton looked at me and saw a confused old woman who didn't understand money, and that mistake cost him everything. I was married to Harold Ashford for 46 years. Harold was a civil engineer for the state of Tennessee. He built bridges, real ones, the kind that hold 18-wheelers over rivers and don't flinch. He was quiet, methodical, and deliberate. Harold never said a word he hadn't already thought about twice. He died 3 years ago, pancreatic cancer. Diagnosed in April, gone by September. 5 months. That is all the time I got to say goodbye to the man I had loved since I was 21 years old. I still remember the smell of the hospital room on the last night, antiseptic, and something faintly sweet, like wilting flowers. I held his hand and his fingers were cold, but he squeezed mine once before he closed his eyes. Harold left me $387,000 in savings. He left me this house on Maple Hill Road, paid off, appraised at $274,000. He left me a small life insurance payout of $125,000. And he left me something else. Something nobody knew about except me and one attorney. In 2017, during what he called a routine estate review, Harold created an irrevocable family trust. He transferred the house, the savings, and the insurance proceeds into that trust. He did it quietly, without fanfare, the same way he did everything. I did not fully understand why at the time. I understand now. Harold and I raised one daughter, Lisa. She is 42 now. She married Craig Pemberton 12 years ago. Craig is a regional sales manager for a medical device company. He wears expensive watches and talks about quarterly targets like they are matters of national security. They have 2 children, Emma, who is 10, and Jackson, who is 7. I love those grandchildren more than I can describe. I pick them up from school every Wednesday. I keep a drawer full of craft supplies just for them. I bake with Emma every other weekend because she wants to learn how to make Harold's banana bread. Jackson builds model airplanes at my kitchen table and tells me about every single part. Those children are my heart. I am not a loud woman. Harold used to say I listen like a bookkeeper. He meant that I hear the numbers people don't say out loud. I hear the pauses, the things left off the page, the totals that don't add up. And after Harold died, I started hearing things from Craig that did not add up at all. It started about 5 months after the funeral. We were having Sunday dinner at Lisa and Craig's house. Pot roast, mashed potatoes, green beans. Craig waited until dessert to bring it up. He leaned back in his chair and said, very casually, that he had been thinking about my financial future. He said I should consolidate my accounts. He said he had a friend who was a financial advisor, someone who could manage things for me. He said it the way you might suggest a restaurant. Light, easy, like it was nothing. I said no thank you. I said I was comfortable with my current arrangement. Craig's smile tightened. His jaw shifted just slightly, and then he said, Dorothy, I'm trying to help. You're 74 years old. You don't understand how money works at this level. At this level, I let that phrase sit in the air. I did not remind him that I had managed a $14 million loan portfolio for 28 years. I did not tell him that I knew what a fiduciary duty was before he knew how to spell it. I just smiled and passed the dessert plate. But I noticed. I noticed the way Lisa looked at him when he said it. Not surprised, not embarrassed. Afraid. She was afraid of what he would do when someone told him no. Later that night, Lisa called me. Her voice was small. She said, Mom, just let him help. He gets difficult when people say no. That sentence kept me awake until 2 a.m. My daughter was not asking me to accept help. She was warning me about her own husband. I got out of bed that night and went to Harold's study. I opened the second drawer of his desk, the one with the brass handles he had polished every spring. Inside was a manila folder. The label read, Ashford Family Trust, Callaway Law. I sat in Harold's chair, which still smelled faintly of the cedar shavings he kept in his jacket pockets, and I read the trust document from beginning to end. I had read it once before, years ago, when Harold first set it up, but that night the words meant something different. That night I understood. Harold had built this trust not just for estate planning. He had built it as a wall around me. I did not call the lawyer. Not yet. Instead, I went to the kitchen and found a small spiral notebook with a blue cover. I wrote the date at the top, November 12. Then I wrote down exactly what Craig had said at dinner. Every word, his tone, his expression, and I wrote down what Lisa said on the phone. I closed the notebook and put it in my purse. That was the beginning. 3 weeks later, I received a bank statement at my P.O. box. I have kept a P.O. box since my credit union days, an old habit that Harold always said was unnecessary. But old habits are not always unnecessary. They are sometimes the thing that saves you. On the statement was a $50 inquiry fee from a service I had never requested. Someone had run a financial background search on my name. I called the service the next morning. After verifying my identity, the representative told me the search had been ordered by a C. Pemberton, using an email address tied to Craig's work account. I wrote the date down. I wrote the representative's name down. I wrote the confirmation number down. Then I checked my credit report. I know how to do this. I spent 41 years teaching credit union members how to read their own reports. I found 2 soft inquiries I had not authorized, both placed in the last 60 days. One of them came from the brokerage firm where Craig's so-called friend worked. I photographed the credit report. I photographed the bank statement with the $50 fee. I put everything in the notebook. I did not confront Craig. I did not tell Lisa. I kept my mouth shut and my eyes open. The next Sunday dinner, Craig brought it up again. This time, he slid a printed form across the table to me. It was a financial power of attorney document, pre-filled. His name was already typed in every blank. He smiled and said, It's just a formality, Dorothy. Makes things easier for everyone if something happens to you. I picked up the form. I read every line. Slowly, deliberately, Craig shifted in his seat. He was not used to people actually reading things he handed them. I recognized the form immediately. It was not from a licensed fiduciary. It was not from any law firm. It was a generic template downloaded from the internet. I could tell by the formatting, the missing notary section, and the disclaimer at the bottom that read, For informational purposes only. I smiled and told him I would think about it. That night, after everyone left, I found something Craig had left behind on the kitchen counter. A printout from Zillow showing my home's estimated value, The address was circled in black ink. In the margin, in Craig's handwriting, were the words, List Spring, 285K plus. He was not trying to help me manage my finances. He was trying to take my house. 2 months passed. I had not signed a single thing. Craig's patience ran out. He called it a family meeting. He organized it at my own house, which felt like a kind of cruelty all by itself. He brought Lisa, his mother Brenda, and his brother Kevin. I was seated at the head of my own kitchen table, but it did not feel like my table anymore. It felt like a witness stand. Craig had prepared a printed proposal. 3 pages, bullet points, bold headings. He said I should transfer my savings, all $387,000, into a joint account with Lisa and Craig for safekeeping. He said I should add his name to the deed of the Maple Hill Roadhouse. He said I should designate him as my power of attorney and my health care proxy. He laid the documents out in front of me like a hand of cards he had already won. You're 75, Dorothy, he said. You live alone. What if you fall? What if you forget to pay a bill? We're trying to protect you from yourself. His mother Brenda nodded from across the table. My mother didn't plan ahead and the state took everything, she said. Don't be stubborn, Dorothy. I looked at Lisa, my own daughter, the girl I carried for 9 months, the girl I stayed up with through fevers and nightmares, the girl whose hand I held on her first day of kindergarten. I said, Lisa, is this what you want? Lisa looked at Craig. Then she looked at the table. She said nothing. Craig leaned forward. He placed both hands flat on the documents, and he said the words I will never forget as long as I live. Sign over the savings, or you will never see Emma and Jackson again. I will make sure of it. The room went quiet. I could hear the children's voices drifting in from the backyard. Emma was laughing about something. Jackson was counting, playing some game. And inside, their grandfather's clock was ticking on the mantel, steady and indifferent. The way time keeps moving, even when your heart feels like it has stopped. I looked at Craig. I looked at the pen. I looked at the papers. And I nodded slowly. I need a few days, I said. Craig's jaw tightened. You have until Friday, he said. I drove home in silence. I did not turn on the radio. I did not cry. I walked into Harold's study and pulled the manila folder from his desk. I picked up the phone and dialed the number printed on the letterhead. Callaway Law, Estate and Elder Planning. The phone rang twice. A woman answered, and my life changed direction. Margaret Callaway is 61 years old. She is an elder law and estate planning attorney with an office on Market Street in downtown Knoxville. She is the woman who drafted the Ashford Family Trust with Harold in 2017. Her office smelled like burnt coffee and copier toner the morning I walked in, 3 days before Craig's deadline. She had framed degrees on the wall, neat stacks of files on every surface, and a ceramic mug on her desk that said, Due Diligence. I liked her immediately. Margaret pulled the trust file from her cabinet. She opened it, reviewed it, and then looked at me with calm, clear eyes. Dorothy, she said, Craig is asking you to sign over assets you legally cannot sign over. They're not in your name. They're in the trust. Even if you signed his documents, they'd be unenforceable. She explained it simply. Harold had created an irrevocable trust in 2017. The house, the savings, and the life insurance proceeds had all been transferred into the trust before Harold died. Legally, I did not own those assets in my personal name. The trust owned them. I was the lifetime beneficiary. Margaret was the successor trustee. Craig could print 100 forms and slide them across 100 tables, and none of it would matter. You cannot sign away what is not yours to sign. But there was more. Margaret told me about a clause Harold had insisted on including. She called it a duress clause. If any beneficiary or family member attempted to coerce, threaten, or manipulate the trustee or lifetime beneficiary into altering the terms of the trust, that person would be automatically and permanently excluded from any future distributions. Harold had put that clause in the trust 6 years ago. He never told me why. Now I knew. He had seen Craig coming before I did. Margaret also told me something else. She said Craig's unauthorized credit inquiries, his background search on my finances, and his pre-filled power of attorney form could constitute attempted elder financial exploitation under Tennessee law. She cited the statute number TCA Section 716117. She offered to document everything and, with my consent, refer the matter to Adult Protective Services and the District Attorney's Elder Abuse Unit. I sat in that chair and I felt Harold's presence in the room. Not in any mystical way, in a practical way. In the way a man who built bridges would protect the person standing on one. Harold protected me from the grave, I said. I'm not going to waste that. Margaret told me to go to the Friday meeting. She told me to let Craig believe he was winning. She told me to say as little as possible. She would be working behind the scenes. And then she said one more thing. And Dorothy, if he repeats that threat about the grandchildren on the record, that changes everything in a custody context too. Friday arrived. I put on my good cardigan, the gray one with the deep pockets. I drove to Craig and Lisa's house. Craig had printed new documents, transfer authorization forms, a deed addendum, another POA form. He had them fanned out across the dining table like he was closing a real estate deal. I played frail. I asked slow questions. I asked him to repeat his terms so I could understand. Craig was happy to repeat them. He stood tall. He spoke clearly. He enunciated every word like he was dictating a contract. And then he said it again. I'm not being cruel, Dorothy. I'm being practical. You sign today, and everything stays friendly. You refuse, and Lisa and I will make sure Emma and Jackson don't visit you again. That's just how it is. I nodded. I picked up the pen. I signed a document Craig had prepared, but it was not the one he thought. It was the cover sheet, a general acknowledgement of meeting, nothing more. I did not sign the transfer forms. I did not sign the deed addendum. I did not sign the POA. Craig was too busy celebrating to check. He poured himself a bourbon. He turned to his mother Brenda and said, "Handled." I asked to take copies of the documents for my records. Craig let me, amused. "Of course," he said, like he was granting a favor to a child. I photographed every page with my phone. Then I left, quietly. In my car, before I started the engine, I sent Margaret a text. He said it again, word for word. What Craig did not know is that I was wearing a small digital recorder in the pocket of my cardigan. Tennessee is a one-party consent state. I was a party to the conversation. Every word Craig said during that 38-minute meeting was on that recording. The demands, the threats, the ultimatum about the grandchildren, his exact phrasing, all of it. Margaret now had the unauthorized credit inquiries, the downloaded POA template, the Zillow printout with Craig's handwriting, the financial background search tied to his work email, the photographed documents, and a full audio recording of coercion and elder intimidation. On Monday morning, she filed two things simultaneously: a referral to Adult Protective Services and a petition to the Chancery Court to formally affirm the trust's duress clause and exclude Craig Pemberton from any future interest. 3 weeks later, I sat in a wood-paneled courtroom in Knox County, Chancery Court, Judge Patricia Harmon presiding. Margaret sat beside me representing the trust. Craig sat across the aisle with a general practice attorney he had found at the last minute. The man was not an estate specialist. He looked like he had reviewed the file in the parking lot. Craig's attorney stood up and argued that I was confused. He said the trust should be reviewed for competency issues. He suggested that a woman of my age might not fully understand the documents she had signed years ago. Margaret did not raise her voice. She stood and presented three things. First, my 41-year career managing a $14 million loan portfolio at a federally regulated credit union. Second, a letter from my physician, Dr. Andrea Marsh, dated 1 week prior, confirming that I was in full cognitive capacity with no signs of impairment. Third, the trust document itself, drafted by Margaret, signed by Harold, witnessed by 2 independent parties, and notarized by a licensed notary public. It was airtight. Then Margaret played the recording. The courtroom went still. Craig's voice filled the room, clear and unmistakable. The savings demand, the grandchildren threat, the phrase, "sign today and everything stays friendly," the follow-up threat that Emma and Jackson would never visit me again. Every word, captured in his own voice, played at a volume the entire courtroom could hear. Craig shot to his feet. His attorney grabbed his arm and pulled him back down, but Craig had already spoken. "That recording is illegal!" he shouted. Margaret looked at the judge, then at Craig. "Tennessee Code annotated 3913601, she said. 1. Party consent. Dorothy was a party to the conversation. The recording is admissible." Judge Harmon reviewed the documents Craig had prepared. She noted that the power of attorney form was a non-compliant internet template with no notary provision. She noted the deed addendum had been drafted without legal counsel. She noted that the transfer authorization forms referenced accounts held in trust, not in Dorothy's personal name. She removed her reading glasses and looked directly at Craig. "Mr. Pemberton," she said, "you asked a 75-year-old woman to sign over assets she does not personally own, under threat of withholding her grandchildren. The court finds this conduct consistent with attempted elder financial exploitation and coercive control." The ruling came in 4 parts. First, the trust's duress clause was activated. Craig Pemberton was permanently excluded from any future distributions or beneficiary status under the Ashford Family Trust. Second, the court referred Craig's conduct to the Knox County District Attorney's Elder Abuse Unit for potential criminal investigation. Third, the court issued a protective order preventing Craig from contacting me about any financial matters. Fourth, the court recommended a guardian ad litem review regarding Emma and Jackson's access to me, noting that Craig's use of the children as leverage may constitute a relevant factor in any future custody or visitation proceedings. Craig's face went white. His attorney began packing his papers into his briefcase without saying a word. I sat still. I did not smile. I folded my hands in my lap. I looked across the room at Lisa. She was sitting in the back row, crying quietly, her hands pressed against her mouth. I did not feel victory. I felt the weight of what my family had become, and I felt the quiet, steady presence of a man who had built something strong enough to hold me up even after he was gone. The consequences came fast. Within 1 week, Adult Protective Services opened a formal investigation into Craig. His employer, the medical device company, was notified because the APS inquiry flagged his background check. Human Resources placed him on administrative leave pending an internal review. Within 2 weeks, the Knox County DA's office opened a preliminary investigation. Craig's unauthorized credit inquiry on my name was flagged as potentially unauthorized access, and an additional charge could attach. Craig's mother, Brenda, called me and left a voicemail. "This is your fault," she said. "You've ruined my son's life." I saved the voicemail. I forwarded it to Margaret. Craig's brother, Kevin, quietly stopped returning Craig's calls. Then Lisa called me. She was sobbing so hard I could barely understand her. She told me that Craig had been controlling the finances at home too. He had taken $22,000 from Lisa's personal inheritance from Harold and invested it in a failed cryptocurrency scheme without telling her. She said, "Mom, I was afraid of him. I'm sorry I didn't speak up." I did not say I told you so. I will never say those words to my daughter. Instead, I said, "Come home when you're ready. Bring the kids." Craig tried one last time. He showed up at my front door at 9:40 on a Wednesday night. I saw him through the peephole. I did not open the door. I called the police. 2 officers arrived within 8 minutes. Craig was escorted to his car. The protective order violation was documented and added to the DA's file. Lisa filed for legal separation the following week. She packed 2 suitcases and put Emma and Jackson in the car and drove to Maple Hill Road. I had the porch light on, I had the beds made, I had Harold's banana bread cooling on the kitchen counter because Emma had asked for it the week before, and I never forget what my grandchildren ask for. Craig sent one last text to my phone. "You think you've won? This isn't over." I took a screenshot. I sent it to Margaret. Then I turned off my phone, walked into Harold's study, and closed the folder in his desk. I did not need it anymore. 6 months have passed since that courtroom. My house on Maple Hill Road is full again. Lisa and the grandchildren are living with me while the divorce proceedings work their way through the courts. Emma has her own room now. I let her pick the paint color. She chose lavender. Jackson's model airplanes line the windowsill in the guest room, and every morning the light catches the wings and throws tiny shadows across the wall. I enrolled in a watercolor class at the Knoxville Arts Center on Thursday mornings. I paint Tennessee wildflowers, mostly coneflowers and black-eyed Susans. I am not very good yet, but the instructor says I have a steady hand. I told her I spent 41 years drawing straight lines in ledger books. She laughed. I meant it. I joined a walking group at the Botanical Gardens. 4 women, all over 70. We walk 2 miles every Saturday morning and get coffee after, at a little shop on Kingston Pike where they know our orders. I volunteer at the county library's literacy program on Tuesday afternoons. I help adults learn to read financial documents, bank statements, credit reports, loan agreements. I teach them what the numbers mean and where to look for the ones someone might be hiding. I call it the most important thing I have ever done. Margaret Calloway updated the trust. Lisa is now the sole future beneficiary. Emma and Jackson each have education sub-trusts that will activate when they turn 18. Craig's name appears nowhere in any document. Not as a beneficiary, not as a trustee, not as a footnote. I tend Harold's garden. He started it the year we moved into this house. 1,986. Tomatoes, green beans, herbs, and 1 stubborn rosebush that blooms every June no matter what. I added a small stone bench near the tomato beds this spring. I sit there in the evenings when the air cools down and the crickets start up and the sky turns that particular shade of orange that only happens in East Tennessee. I talk to Harold sometimes. I don't hear him answer, but I feel the bench under me. Solid and steady, and that is enough. Harold could not fight for me anymore, but he built something that could. And I had 41 years of reading fine print. Craig never stood a chance. Not because I am smarter than him, but because I paid attention. I am sitting at my kitchen table right now, the same table where Craig made his demand. Emma is beside me, drawing a picture of a horse. Jackson is eating a peanut butter sandwich and telling me about a book he read at school. Lisa is washing dishes at the sink and humming a song I used to sing to her when she was small. The manila folder is back in Harold's desk. The spiral notebook is closed. The house is quiet, and it is mine. If someone threatens to take away the people you love unless you give up everything you have built, that is not family. That is extortion. And the answer is never to surrender. The answer is to prepare. It is never too late to protect yourself. Not at 60, not at 75, not at 90. You do not need to shout. You do not need to fight with your fists. You just need to document. You need to pay attention. And you need to find one person who knows the law. What would you have done at that table? Would you have signed? Would you have fought right there in front of everyone? Or would you have waited like I did? Tell me in the comments. I want to know. If this story meant something to you, please press like. Subscribe if you haven't yet. Share this with someone who needs to hear it. Maybe someone who is sitting at a table right now being told they have no choice. And tell me, which city are you listening from? I want to see how far Dorothy's story travels. Thank you for listening, dear ones. Until next time, protect your peace, protect your proof, and never let anyone tell you your worth has an expiration date.